Good morning. We are back on the record in the case of Gardner versus Cadence. And I just wanted to note for the record the change of panel. I am Judge Michelle Christensen Forster, and I am joined on this panel by Judge Gregory Orm and Judge Amy Oliver. We have called you all to this hearing to ask you a few questions about a petition that was filed by Mr. Durbano and Mr. Who signed it?
Bednar.
Mr. Bednar, who actually signed the petition. There was some information we received from the other side about that petition that contained some errors and some problems. Before we begin the actual hearing, could you please enter your appearances for the record?
Morning, Your Honor. Matthew Barnick appearing for the respondents to the order of show cause, Douglas Durbano and Richard Bednar.
Thank you.
Greg Salin and Cody Condes appearing on behalf of the respondents to the petition. I know we're all saying we're respondents, but
yeah,
we're defendants in the underlying case.
Thank you. I think I will open it up to the panel to see if there are any introductory remarks that you would like to give, Mr. Barnick, and then I will open it up to the panel for some questions.
Thank you. I'd be happy to. I'll give at least some introductory remarks, and then I can address whatever the court would like. As mentioned, I represent Mr. Durbano and Mr. Bednar on this order to show cause only. I do not represent Mr. Garner in the underlying case. This filing was a serious mistake. My clients apologized to the court, to opposing counsel and their clients, and certainly to their own client. They are embarrassed about this. They are disappointed in themselves and in the failure of their normal process that led to the filing of this petition. I don't know how much you want to hear from me up front, but I'd like to explain what we think happened here and what the firm has done to measures it's taken to make sure it doesn't happen again. And if I may, I'd like to add a little bit of background about Mr. Durbano and Mr. Bednar that leads up to the filing of the petition. Doug Durbano has practiced law in the state of Utah since 1984, and during that entire time has been a member in good standing of the Utah State Bar Association. Mr. Durbano had little, if any, involvement with this petition for interlocutory appeal. He's, of course, been involved in the underlying case. Doug was involved in a car accident on February 12th of this year, and for the next week or so was in the hospital recovering and out of the office, returned to work on February 19th. This petition was filed on February 18th. It bears his name, but it does not bear his signature. Richard Bednar is the attorney responsible for approving, signing, and filing the petition. Richard graduated from BYU Law School in 1989. He then clerked for 2 years in Washington, D.C. at the U.S. Court of Appeals for Veterans Claims, and then remained a staff attorney with that court for about 15 years and ultimately returned to Utah in private practice. Because of his involvement in the court system, he has a deep understanding and commitment to the accuracy of court filings. He has never used AI to generate a brief or to generate case citations, with the exception of the LexisNexis AI tool. but his practice has always been to review and approve cases before they are cited in any filing with the court. That didn't happen here in this instance. What happened here was that Richard asked a law clerk in their office to prepare the initial draft of this petition. Richard then did some work on it, and he and the law clerk exchanged drafts back and forth as those things go. And ultimately it was filed. He did ask that those case citations be checked, and later learned that didn't happen. But Richard did not do that himself. He does not point fingers at others. I'm simply trying to add context. He takes responsibility for this. He is the licensed lawyer who signed the petition, and it was filed with the court.
So do I infer then that it was the law clerk who used Chat GPT to generate some portion of the filing?
Yes, that's correct. That's correct.
Is the law clerk licensed to practice law?
No. No, and that's why I say Richard takes responsibility. He's the one who is licensed. They work together on the document, of course, but ultimately the lawyer who signs and files it is the one responsible. We all know that. And Richard's not trying to hide from that responsibility today. I'm happy to...
Was Mr. Bednar aware that ChatGPT was being used to draft the petition?
No, he was not. And thank you for that question. I began by saying this was a serious mistake, and it was, but it was a mistake. It was not knowing. I don't believe it even satisfies the standard for recklessness. He did not know that AI had been used to generate anything in connection with the brief until after the fact, when they went back to try and reconstruct what had happened here, and then learned that yes, it had been.
And were there any conversations at any point prior to this brief being drafted about the use of AI in their practice and at their firm by this law clerk or any other employees?
To my knowledge, no. I don't think I've asked that specific question. But I've certainly asked that question about, going forward, and that AI was used. We acknowledge that in the generation, but I don't believe that Richard or Doug knew that in the drafting stage before it was filed.
And I'm asking more generally, did the firm have a policy, maybe something less formal than a policy for their employees about using AI or ChatGPT to generate work product?
I don't believe so. And I can stop to ask my clients specifically if you would like, but we've had a number of discussions and they haven't mentioned that to me, so I don't believe that was any kind of a policy. I can tell you there is a policy now, I think there is a place in the world for AI, but it certainly isn't the place to write your brief for you and find your cases for you. We acknowledge that.
Well, I don't think it's the position of the court that AI isn't a tool that can be used by lawyers and whatever assistance it may provide. I think the concern we have is obviously that in this case, ChatGPT hallucinated at least one case and probably cited other cases for propositions that were unrelated to those cases in their holdings. And a lawyer didn't check that, right? We as attorneys, as you've said, when we sign documents for filing with the court, we're making a representation under the rules about the veracity of the information contained in whatever the document is that we're filing, and that's a responsibility we bear. So while AI is certainly a tool that people appear to be using successfully, here it obviously was unsuccessful, and there apparently wasn't an effort made to double check it. And that's really the concern, I think, for this court, is that there was a failing on the role of the attorney to make sure that what was being presented to the court was in fact accurate.
Well, then it implicates, in my mind at least, the duty of candor to the tribunal.
Yes.
Here is this case, and it supports our position, and the case doesn't exist. That moves it, in my mind, beyond a mere error. An error would be it's the wrong pin site. We didn't realize the case was later overruled by the Utah Supreme Court. There are but I was going to say 1,000, that's an exaggeration. There are a bunch of cases in Utah called State versus Carter. Quite by accident, we cited the wrong State versus Carter. That's our error. It doesn't really support the proposition. But where you have a case that's non-existent and represent to the court by signature that this is valid authority, that's a more serious problem in my mind than a mere error.
Understood. I hear what you're saying, and I do think that the court needs to look at this as to what Mr. Bednar knew at the time the petition was filed. He did not know, and by imposition of duty, he should have known. We acknowledge that Royer versus Nelson is a non-existent case. It actually exists in Indiana as a table citation. There's no content to it. It is a fake citation, but it was never intended to be that way. And that's the point I emphasize today, is what was in the mind of Mr. Bednar at that moment. I will say, harking to a part of Rule 3.3, they have filed a request for leave to file an amended petition, in part, of course, to protect their client from the effects of this initial petition, but in part to correct the misstatements in the original one. That's one of the requirements in Rule 3.3, and they have done that. Now, what the court does with that request is not within the scope of my representation, but I point that out.
Nor really within the scope of the hearing,
this
but we're
hearing.
mindful of the.
Yes.
And
of
let
the
me
file.
ask this, is the client, Mr. Gardner, aware of the order to show cause and order and the hearing that was set today?
Yes, and I believe he's here. Mr.
Oh,
Gardner is
Mr.
here.
Gardner, all right, thank you.
That has been disclosed to him fully. It was not a pleasant phone call for them to make to their client, as you might imagine. But they have been completely upfront with them since learning of this, and have tried to be the same with the court through our presentation today. And I had a conversation with Mr. Salin last week to attempt to accomplish that same purpose. I'm prepared to go through each of these citations if you want to drill down to that level.
I don't think so. We can do that.
But I will say, certainly the Royer versus Nelson case does not exist. The Westside Nursery and the Granite something construction case, they are real Utah cases, but they don't stand for the propositions for which they are cited. The Jones-Waldo case, I think, is appropriately represented in the petition. State versus Wilden, State versus Spry are also appropriately represented. They probably aren't on point ultimately, but I think as far as what's stated in the petition about those opinions, I believe that's correct. And like I say, that's my summary. I'm happy to address that further if you'd like. And I will say that I mentioned something earlier, but the firm has adopted a formal policy now about how they will handle the writing and the submission of any filing with the court, but in particular those that cite case law. I'm happy to walk through that with you, just a 4-step process, but I want you to know that that is something that they have done. It's a small firm, but it is a formal policy now. They don't ever want this to happen again. Last thing I will say is, I guess 2 points, if I may.
While you're
Yes.
recapturing your thought, I was impressed, for what it's worth, that your clients promptly acknowledged that they should pay the other side its attorney's fees insofar as they were inconvenienced in having to respond to the bogus authority. I thought that was an appropriate
Thank you.
attitude. I'm not sure exactly how we go about, I don't know if an offer has been made or.
An offer has been made. I know Mr. Salin and his clients have considered that. The offer is still open. And I think Greg and I can easily communicate about that more if they're interested. But the offer is to pay all of the legal expense incurred in responding to the initial petition. I suppose more if that is deemed to be warranted.
What would be your position about a monetary sanction above and beyond making the other side's attorneys whole in view of the misrepresentation to the court? I know around the country, we did a little research, and where this has come up before, this is not the first time it's happened in the country. This is happening all the damn time. Sanctions of $1,000 here, $5,000 there have been imposed by courts around the country, I guess, to sort of
Make the point.
make the point, send the message more strongly than just making the other side whole would do. And I'd be interested in your position about the propriety of some such sanction in this case.
I think that's well within the scope of Rule 40 and what the court can do here. That's certainly not something my clients would love to hear, but they understand that is a potential outcome of the hearing today. Rule 40, is it C or D? I've forgotten. That I think gives the court fairly broad discretion in imposing sanctions.
And
or referring.
obviously, neither that sanction nor the attorney's fees to be paid to the other side, those wouldn't fall to the client. The attorneys would be responsible for that personally. I assume there's no issue on that.
They would be responsible for the attorney fees for sure. They would not charge their client for that. The attorneys would pay those attorney's fees, and I assume the same would be true if the court imposed a monetary sanction as well. I don't think any of that can be passed on to a client. Right. I guess I would. Sorry, Judge Oliver.
Yeah, I would just like to say, I think a concern I have in general, and this factors into at least my view of whether sanctions should be imposed and what amounts they should be, is that we had the benefit here of opposing counsel who pointed out to the court the use of citations that were hallucinations and didn't exist, and case citations that were incorrect as a proposition of law. We as a court system, as everyone knows, we're very busy. We have more work probably than we can do as quickly as we would prefer. And so it can't be that the judiciary is the backstop to double check and triple check every citation that's made in a filing that's presented to the court. We simply don't have the resources or the time to do that. And so what we do is we depend very much on the honor system of those attorneys who practice before us. And that is part of our rules, Rule 3.3, Rule 40, sure, that when a document is presented to the court with a signature of a licensed attorney, that we can trust that what's being argued in there is being argued in good faith and based on real cases and case law, and is a valid and good argument for the extension of the law. And I think if this problem were to become more widespread, it's a larger problem for the judiciary and the integrity of the judicial system. And so I just want to say for the record that this is something that we have grave concern about, and something that we need to make sure that attorneys have grave concern about, and that they make every effort to make sure that what they present to this court under their signature is accurate to the best of their abilities. We certainly understand that errors may occur, typographical errors, miscites and things of the nature that Judge Orm discussed. This is an entirely different category, and so that is why we called this hearing, which is quite unusual for the Court of Appeals to do. And so I say that just to explain why really we're here today. We take this matter very seriously on behalf of not only our court, but the entire Utah judiciary, and it's something that is very serious.
Absolutely, thank you. And I confirm that my clients are committed to upholding the honor system that the court has just articulated. And they have learned that lesson in a very difficult way. And as I said, they come here embarrassed and disappointed and perhaps more firmly committed to make sure this never happens again than someone who hasn't been involved in this kind of a failure.
Well, and certainly we appreciate and recognize, I mean, we've all been around for a while and we don't necessarily understand the nature of this new technology as well as we all should, right? But Judge Oliver is correct that it can't be the courts that that harness and utilize this technology as a check on anybody, right? We have to count on the attorneys to utilize it correctly.
Absolutely.
If they are going to be. So.
Yeah.
Well, and I was thinking, how in the heck would these guys, people of my own approximate vintage, how in the heck did they know how to use AI?
Yeah, I don't.
And your explanation, of course, they don't. But they have a law clerk who does.
I
And
bet
so
you
it's
do
really-
now, though.
Really more of a failure to supervise situation, lack of candor to the tribunal, rather than, wow, my contemporaries are on top of this AI thing, I'm impressed. This was a explanation, I have to tell you, I kind of anticipated. That it was an underling of some sort that kind of went nuts with Chat GPT and let AI write the brief that the law clerk should have been drafting, or the petition that the law clerk should have been drafting. But yeah, the whole thing kind of makes me really
Feel old.
nervous and queasy, and the less I know, I shouldn't say the less I know about it, the better. I obviously need to
Undertake the
to
counsel
understand
of.
it. Some few months ago, judges were all asked to take a poll about AI and their use of AI and so on, and then there was an open-ended question at the end, and I completed that question by saying, as far as I'm concerned, there's so much real intelligence in the judicial branch, we don't need the artificial intelligence.
Yeah, I understand that. I think the last thing I was going to say was just to point to some case law. Rule 3.3 talks about knowing and reckless, and there's some history with that. It didn't always say reckless, but I haven't found any citations to mens rea standards in the context of the rules of professional conduct, so I looked to the broader Utah law for that. This is well defined in many cases. Negligence is a failure to exercise the degree of care which a reasonable person would have exercised under the same circumstances, whether by acting or by failing to act. And I believe if the court is looking for a mens rea standard to latch onto, that's the one that I think fits here. Utah law, interestingly, defines recklessness within the context of gross negligence, that recklessness is subsumed by the court's definition of gross negligence, and that is the failure to observe even slight care. It is carelessness or recklessness to a degree that shows utter indifference to the consequences that may result. I don't believe the facts here can satisfy that standard. That is for the court to determine, of course. But if you ask me, does it satisfy the negligence standard, I would have to say I think it probably does. But I'll leave it at that unless your honors have any further questions from me.
I was smiling not to be in uncorrect or whatever, but Judge Orm and I just sat on the oral arguments that we had just before this. That same exact phrase and standard was discussed. So
I heard that.
we may have a little familiarity with utter indifference.
Right.
Yeah.
Okay, thank you very much.
Thank you. Did you have anything, Mr. Salem, that you would like to respond to?
No, Your Honor, thank you.
Okay. Well, thank you both for being here today and for, we do very much appreciate your acknowledgement and the respect that you are handling this. We appreciate it. The judicial system appreciates it as well. We will take this matter under advisement and render a decision at a later time.
Thank you.